Right. Let's call this meeting to order at the strike of 9. Do you want to, Mary, first inform everybody about the recording?
Absolutely, thank you. There is a notice that's posted on the Teams call-in, but I wanted to also make a statement that the meeting is being recorded. By continuing to be in the meeting, you are consenting to be recorded.
Thank you very much. Well, welcome everybody. Great attendance. I have a feeling I know what everybody is here to discuss, and we're going to welcome comments both virtually and in person today. Let me start and open the meeting by taking a roll. Commissioner Reddycliffe. Here. Commissioner Parcells. Here. Commissioner Caruso. Here. Commissioner Vassallo.
Here.
And I am present. So we have all of the seated commissioners here and a quorum to start our meeting. Pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting immediately prior to the executive session or the next meeting after. An executive session will be held today, July 23rd, 2025, immediately following this session to review matters that are by statute confidential, including the review of completed investigation for the purpose of issuing a final adjudication and administrative matters. With that, the minutes of the April 9, 2025 public meeting have been circulated. Has everyone had a chance to review them? Are there any corrections, comments, or changes to be made? May I have a motion to adopt the minutes?
So moved.
Second. All in favor? Say aye. Aye. Any opposed? The minutes are adopted. I have taken upon myself the defaults of the civil penalty orders. We have 8 of them today. The respondents involved in these cases will be identified individually in the motion that I will be making regarding these cases. These 8 respondents failed to file statements of financial interest for the calendar years that I'll detail in my motion. The respondents did not take any action or otherwise respond to the civil penalty proceedings. Following review, it is my opinion that as to each respondent, the Commission shall levy a maximum civil penalty for each delinquent statement of financial interest. It is my opinion that the Commission should also order these respondents to file their delinquent statements of financial interest. There is nothing in the record that would constitute a defense or excuse for their non-compliance with the requirements of the Ethics Act. So based on these comments, I would like to make the following motion. I would move that the Commission levy a maximum penalty in the total amount of $250 each against each of the following respondents for failing to file statement of financial interest for the calendar year 2023. And I'll list the names and the positions they're with. Alan Artachi, an air quality specialist with the Pennsylvania Department of Environmental Protection. Lawrence Fowler, a constable or a deputy constable. Samuel Barner, a corrections officer 4 with the Pennsylvania Department of Corrections. Amelia Benson, an environmental community relations specialist with the Pennsylvania Department of Environmental Protection. Albert Ciccarone, a forest insect pest aide with the Pennsylvania Department of Agriculture. Patsy Belaphone, with a member of the Pennsylvania Council of the Arts. Vladimir Shetin, fixed utility valuation engineer with the Pennsylvania Public Utility Commission. And Terrence Crumbie, a constable. I move that these respondents shall be ordered to file complete and accurate statements of financial interest for 2023 within 30 days of the issuance of the commission's order. Do I have a second? Questions? Any comments? All in favor, say aye.
Aye.
Aye. Any opposed? Motion carries. Next on our agenda, we have a lobbying default. Commissioner Parcells.
There is one default administrative penalty case for our consideration. Respondent Button Holdings, Inc. is a registered principal that failed to timely file either a quarterly expense report or a statement of failure to meet the reporting threshold for the fourth quarter of 2024. A warning issue was issued to the respondent, but the respondent failed to comply with the 30-day cure period provided. Based on the record before us, it is my view that the respondent's transgression of the lobbying disclosure law was negligent. In accordance with the Commonwealth Court's decision in Penn Film Group, the record was examined for any mitigating factors, such as those outlined in section 63.63 of the Commonwealth or the Commission's regulations. Other than this apparently being the respondent's first delinquent filing, there is no evidence of any other mitigation present in this case. In the absence of any other mitigating factors or records, we conclude that a maximum civil penalty in accordance with section 13A09C of the lobbying disclosure law is appropriate in this case. So I'd like to make the motion that based on the totality of the circumstances in this case, including lack of mitigating factors, I move that this commission levy upon respondent Button Holdings, Inc. one maximum administrative penalty in the total amount of $32,300 for its failure to timely file with the Pennsylvania Department of State either a quarterly expense report or a statement of failure to meet the reporting threshold for the fourth quarter of 2024. Finally, I move that the respondent be ordered to pay the aforementioned administrative penalty by no later than the 30th day after the mailing date of the Commission's order. That is my motion.
Second.
Any comments, questions? All in favor of that motion, say aye.
Aye.
Aye. Any opposed? Motion carries. We also have a consent in a lobbying case. Commissioner Caruso.
There is one administrative penalty case with proposed consent agreement for the Commission's consideration. Respondent Milne Spirit Works LLC failed to timely file its quarterly expense report for the fourth quarter of 2024 in its capacity as a principal. Parties agree that the respondent's transgression of the lobbying disclosure law was negligent. Respondent has now submitted its delinquent expense report to the Department of State. Based on my review of the facts, in particular, considerable mitigation offered by the respondent as set forth in the order, I am of the opinion that the consent agreement sets forth a proper disposition for this case, and I would like to make the following motion. I moved that this commission approve the consent agreement submitted by the parties and impose the following administrative penalty. As to Milne Spirit Works LLC, one administrative penalty in the total amount of $4,550 for its delinquent expense report for the fourth quarter of 2024. I also move that the respondent be directed to pay this administrative penalty to the commission by no later than 30 days after the commission's order. That is my motion.
We have a second.
Second.
Any comments? The only thing I'll say on this is I think it's important, especially with the Penn Film Group decision, that we look at mitigating factors that are laid out here. And I think the proposed result here shows that for respondents who engage with the commission, that there is a big benefit to engaging even if you fail to comply. I know oftentimes our enforcement people will try to bring compliance without an action, but even after the time appears when you compare the last matter that we just handled in the penalty and the proposed penalty here, there's certainly an incentive to come into compliance. So I appreciate the work of the investigative division on this. With that said, we have a motion and we have a second. All in favor? Aye. Any opposed? Motion carries. We have a gaming determination and opinion and request. Commissioner McKee Vasala.
Thank you, Mr. Chair. The requester, John Eric Polee, requests a determination from the Commission pursuant to Section 1512(8.51) of the Pennsylvania Racehorse Development and Gaming Act, which I will refer to as the Gaming Act from here on out, as to whether his service as an auditor for the Hughstown Borough, in Luzerne County would bring him within the definition of the term public official as set forth in Section 1512B of the Gaming Act, and therefore cause him to be subject to the restrictions of Section 1512(8.1) of the Gaming Act. I want to first lay out the facts that are pertinent to this advisory request. Mr. Polee, who has been employed as a barback with the Mohegan, Pennsylvania Casino Resort in Wilkes-Barre, Luzerne County since 2012, is registered as a non-gaming employee with the Pennsylvania Gaming Control Board, or the board as I'll refer to them from here on out. In November 2021, Mr. Polee was elected as an auditor for Hughstown Borough. When Mr. Polee subsequently submitted an application for renewal of his non-gaming employee registration to the board and disclosed his status as an auditor, a concern was raised that Mr. Polee may be considered a public official as set forth in Section 1512B of the Gaming Act. At the request of the board, Mr. Polee seeks a determination from this commission as to whether his service as an auditor for Hughstown Borough would bring him within the definition of the term public official as set forth in the Gaming Act. I want to note, though, that he did not actually run for the position. He was written in by those who appeared and voted during that election. I believe that this commission should take administrative notice of the following. Under the Gaming Act, licensed casinos must pay a local share assessment levied against revenue generated by gaming, which the Commonwealth collects and distributes to counties and municipalities to mitigate the impact of gaming and related activities. The Pennsylvania Department of Community and Economic Development, also known as DCED, issues an annual report identifying all distributions of local share assessments to counties and municipalities. These annual reports issued by DCED provide that Hughstown Borough has received distributions of local share assessments totaling $500,000 in 2015, $100,000 in 2017, $115,000 in 2020, and $11,708 in 2024. Mr. Chair, I would suggest that now would be an appropriate time for any interested parties to speak on the matter.
Thank you. Is Mr. Polee or any other interested parties either in the room or on our video? Hearing none, why don't we proceed?
Mr. Chair, I have reviewed the submitted and administratively noted facts and relevant statutory provisions. I would note that the Gaming Act in pertinent part defines a public official as an individual elected or appointed to any office of a county or municipality that directly receives a distribution of revenue under the Gaming Act. It is clear that as an auditor for Hughstown Borough, Mr. Polee is an individual elected to an office of a municipality. It is further clear that Hughstown Borough is a municipality that directly receives distributions of revenue under the Gaming Act's local share assessment system. Accordingly, it's my view that Mr. Polee's service as an elected auditor for Hughstown Borough brings him within the Gaming Act's definition of the term public official. Therefore, I would like to make the following motion. I move that the holding of this commission in this matter be as follows. Based upon the submitted and administratively noted facts, as an auditor for Hughstown Borough, Luzerne County, Pennsylvania, John Eric Polee is a public official as Section 1512B of the Gaming Act defines the term. Therefore, he is subject to the restrictions of section 1512, 8.1 of the Gaming Act.
We have a second to that motion.
Second.
Any discussion?
If I may, Mr. Chair, I wasn't sure when the appropriate time was to say this. We are constrained to apply the law as it has been presented to us. It is not to change what the law is or to read into the law what the intent is. The reason why I mentioned that Mr. Polee was written in, he rose to the call of the people of his community to serve his community. At the same time, he works in a relatively low-level position as a bar back, making very little money at the Mohegan Casino. While I personally have a hard time believing that this is what the legislator intended, we are constrained to apply the law, which is why I make the motion I make. But I note that there is a seeming inconsistency between what the purpose of the act is and what the motion says.
Well said.
Yeah, very well said. And also, it does not appear that Mr. Polee himself ever intended to violate this statute. I think the gaming board appropriately referred this matter for the opinion, and I think probably we all share your opinion that the statute requires us to come to this conclusion, whether or not this bar back position should be subject to requiring a license that doesn't mean that you're also able to serve as a public official is something for the legislature.
Sure, just as is the definition of a public official, even a public official that only meets once a year for $400.
Right.
And so on both ends of it, we've got an issue that is difficult in one sense, but on another, we're just reading it strictly here, and it's unfortunate for him.
Right, with those comments, any other comments? Okay, all in favor of the motion, say aye.
Aye.
Any opposed? Motion carries. Thank you. All right, we have some, 3 administrative matters before we get to probably why everybody is in the room and everything else. Mary, do you wanna touch on the, first 2 administrative matters?
Yes, thank you. Number 6 on the agenda is a request for a general pay increase and one-step service increment for all staff. I always bring these requests to the commission for their approval. We had put this on the agenda in the hopes that we would have a budget at this point. As we do not, I'd like to defer this request until the next meeting before the commission.
And I'll just note for the public record that generally the commission also will consider whether or not to adjust any of the pay of the executive director and the chief counsel. As part of that process, we have set up a formal process of evaluation. We have done an evaluation of the chief counsel and the executive director that has been shared with all of the commissioners. We will also defer consideration of that. I think we've talked about it and we agree it's fiscally responsible to wait till a budget is in place, and we'll consider hopefully your request and any other request at our next meeting.
Thank you. The next item on the agenda is the operational report. And I'd like to just highlight some of the work of our administrative, investigative, and legal divisions at the commission. I note our budget for fiscal year 2024-2025. We have approximately $414,000 of unused funds. We have requested approval to be able to use that in a subsequent fiscal year. We did receive some approval. We're waiting on final approval, which we're hoping to receive next week. Our plan for some of those funds is to use them towards a upgrade to our statement of financial interest online filing system. So we're hoping for that approval. We completed our annual report for the year 2024. I'd like to make a call out to Julie Gibson and Cindy Hirschberger on our team. They took a lot of effort to reach out to everybody that we had previously provided paper copies of the annual report to, asking if they would accept it in a PDF version. They had a great amount of success, saving the commission about $1,200 in print printing costs alone. So wanted to give kudos to our team for taking those efforts and saving funds in that way.
Thank you.
We've continued to do a ton of external training to public officials, public employees in Pennsylvania. Currently, we have 37 training sessions that we've either completed or we have planned to complete before the end of this fiscal year. We're on track to exceed last year. Last year we did 39. That was the highest that we've ever, at least in our written records for the commission, it's the highest number we've ever done, hoping to exceed that this year. So far, we believe we've trained over 2,000 individuals. We're trying to make these more accessible. We've done them online, open them to the public. We're also going to train it live up in Erie in August. This is an area of the state we don't get to too frequently, just because of the distance. So we have worked with the State System of Higher Education. We're using a conference room at Penn West, formerly Edinburgh University, and we have a nice number of people who have signed up for that training. We're also going to offer continuing legal education credits for any lawyers that attend. So we're happy about that, and we'll continue to train people. Like I say, I will talk to anybody about ethics who's willing to listen to me, so we'll keep doing that. We have also done quite a bit of staff training. Just some highlights. Our Director of Administration, Jessica Wenger, this year completed Harrisburg University's Leadership Development Program in January. Jennifer Lehman, our Director of Enforcement, Litigation, and Education, is currently attending the Commonwealth Leadership Development Institute offered through the Pennsylvania Office of Administration. Our Assistant Counsel, Julie Carabin, was recently accepted into the Pennsylvania Bar Association's Bar Leadership Institute. We've attended other supervisory trainings. Our Chief Counsel, Bridget Guilfoyle, recently attended the supervisors training offered through the General Government Human Resources Delivery Center. And we've done procurement-related trainings. Our special investigators are attending testimony training provided through the Northeast Counter Drug Training Center in September at Fort Indiantown Gap. And our newest special investigator, Kendall Trunzo, will be attending the Civil Investigator Training Program offered by the Pennsylvania Office of Attorney General. So we are busy training and making sure that our staff is up to speed and are able to function at the highest levels. In 2025, the Commission's legal division has issued 30 advisory opinions. So they're busy, very busy with that. In 2025, the investigative division has opened 35 cases. We continue to refer enforcement matters to the Office of Attorney General. 9 of them were successfully collected this year, and 7 were determined by them to be uncollectible after extensive research by that section. So we are having success. We look forward to continued collection and enforcement of those matters. Our 2024 SFI filing season is complete. We received 12,920 statements of financial interest. Just shy of 5,000 of them were required to file with the Commission. That means that others are voluntarily filing with us. We had great cooperation this year in getting everyone filing. We had just one sort of high-level position that they are a former public official, and we have begun our civil penalty process to get compliance on it. We are taking a look at all of our processes as well to make sure that the folks who are handling them are the best people to handle them. One of the tasks we perform are compliance reviews. So we do that by going out to a governmental body, taking a look at all the positions and who serve in those positions and when, and then comparing those to the statements of financial interest that are on file. In many instances, historically, those were performed by our investigators. We think that they may be better handled by our administrative division, and so we're working towards transferring those duties to our administrative division to make it easier all around for our team. We are continuing working to develop a new and enhanced statement of financial interest filing system. We've just begun development meetings with Sapient. They're a Commonwealth contractor who's helping us with that. We're hoping to make the filing process much easier for filers and be able to get additional compliance. I'm happy to report we are fully staffed. Kendall Tronzo is our most recent hire in our Western Regional Office. She came to us about a month ago, and she's doing a great job getting up to speed on our processes.
Congratulations
Thank
on
you.
bringing
Thank you.
our investigative staff
Thank you. Yes,
back up the full complement.
as you know, we've had some issues with staffing, especially on our investigative team. We've been able to hire some really fantastic individuals, both here and out in our Pittsburgh office. We have wonderful momentum right now, and I'm very excited about the work that we're doing and the quality of the work that our investigators are doing. Yes. We are looking to relocate. We will be actually relocating across the hall from our current spot. We are currently at 309. Our new office is going to be 304. This is about double our footprint. It's going to allow us to work together better. I'm really, it's an upgraded space. It's much larger and it's much nicer. I encourage anybody who would like to see it to see me after the meeting. I'm happy to give you a tour. We still have a little bit of interior construction that needs to be performed, but we're looking to do the formal move by September of this year. The advantage of this is that we're able to keep this conference room, which I'm very happy about because this is a great space. We have great technology here. But when people from the public come to visit us after September, you're gonna have to come across the hall. But we're all looking forward to that move. And then finally, I wanted to call out, we have a program that's, it's called SECA. It's the State Employee Combined Appeal. It's a program that's offered across the state where agencies encourage their employees to donate to nonprofit organizations. We had a great deal of participation by our team this year. In fact, we, for a small agency, which is defined as an agency of 1,000 or fewer employees, we have 21 employees, but for a smaller agency, we actually won the SECA award because our team, we participated 175% more than what was expected and allocated for the number of employees that we have here. So we won the SECA award, which you can see, we've displayed it in our conference room. We're very proud of that, and I wanted to recognize our employees for their participation in that worthy cause.
Wonderful.
Does anyone have questions about the operational report?
Hearing none, we've heard about, during that report, the investigative division, the administrative division. I think now, Bridget, you're going to give us some reminders as a administrative agency that does investigations and adjudications. We have certain legal rules that we have to abide by, and we have an annual reminder of both those rules and our own conflict and recusal guidelines, and I'll turn it over to you.
Thank you. Yeah, this is something that I started with this commission last year, and it has been something that was done in my prior position with the Department of State, that we would do an annual reminder of one of the most important cases for any agency that does do investigations and adjudications under the same umbrella, which we do here. Obviously, this case is the Lioness case, which will come in great handy here as we discuss the regulations later, because a good bit of it has to do with whether we are satisfying the requirements of Lioness. Lioness really is a very simple case. It's a simple premise that the due process requires that the prosecution arm and the adjudicatory functions cannot be commingled. And what we have to do is construct what they always call the sufficient walls of division to eliminate the threat or the appearance of bias of the adjudicating arm versus, as opposed to the, or I should say, bias in favor of the prosecution arm under the same umbrella. And the thing that we need to always remember is that we don't need to show actual bias. It only needs to be the appearance in order for this to be considered in violation of the Lioness decision. And this case has been around since, I think, 1992. And it's a very well-cited case for issues that various agencies, departments have had over the years, making sure that there is a sufficient wall of division. I believe that we have that here. The legal division is obviously just myself, Martin Harder, and Esther Estelle. We are separate from the remainder of the commission staff, and we do not discuss any type of cases or anything like that with the prosecution or investigatory staff. And so to that end, I just want to remind everybody, and that includes everybody that sits on the commission, that no discussions of pending investigations or pending cases should ever be had with anybody other than me, Martin, or Esther. I'll throw her in as well. So the other thing that I wanted to remind you of is you have very specific recusal guidelines that are set forth in your regulations. And there are two different types of recusals that the regs speak to. One is mandatory and the other is discretionary. The mandatory part of your recusal guidelines states that if you have direct personal or direct financial involvement with a party, then you must recuse from that matter. The discretionary one is where we usually run into, anything that would be a question, and that the discretionary arm of this is described as substantial prior contact. That's obviously up for interpretation as to what substantial prior contact would mean. The discretionary aspect of this also sets forth 3 specific things, one of which you must do if you fall into that discretionary category. In my mind, the bottom line is, if you're even thinking that you have a recusal issue, please discuss it with the legal office before you make any determinations. We need, to make sure, and I think we've done a very good job of making sure that nobody has any even potential issue that is not addressed prior to either the commission meeting or a hearing with the investigative division and another party. So I think we've done a great job of working on recusals, and we've had some. Like I said, would just like to remind everybody, if you have any questions about it, if there's something in the back of your mind that you're thinking maybe I should recuse, please call me and we'll discuss it. So with that, I'm going to, do you want me to turn it over to what I think everyone is here for and what you think everyone is here for, the regulation discussion?
Let me just, any questions, comments about Linus recusal? I think it's really important, and I appreciate, Bridget, that you have been doing what will become an annual, it's now been the 2nd year, reminder of our obligations that we have to take seriously. Just want to make sure if anyone has any questions or comments about that. So let's move into regulations. I know there's a lot of interest and comments, and we really appreciate that. Let me suggest, having talked to the vice chair, just the process that I think we're going to use and see if this makes sense to everybody. Chief Counsel Bridget Guilfoyle is going to go through section by section the comments that we have received. I think so that we all can understand any of the comments that have been received, we will take further commentary as that section's being done. So you can get up multiple times, those online can participate more than once. We really value everybody's input. At the end, if there are broad comments or something you forgot to say, we'll give everybody a chance to comment again. We may have questions, and I welcome the commissioners to ask questions when comments are made, make their own comments. Our plan as of right now is to consider everything that has been given to us in writing, everything that we hear today. And what we intend to do, we've gotten a lot of great comments that are non-controversial that we will incorporate. We have gotten stylistic comments that we very much appreciate and will be incorporated and probably don't need to have any further discussion on the stylistic, and we do appreciate, we want to get this right, we want it to last on. And then there are some substantive comments that are open for discussion and debate. Our view of this process, we are not looking to legislate or change the Ethics Act. We're looking to clarify and put common sense rules in place so that everybody knows what the rules are. They're modernized and adopted because they haven't been for so long, and that they're practical from the standpoint of everyone. Parties that are regulated by the Act, parties that are interacting with the Commission in an administrative capacity, seeking opinions, or involved in the adjudication process, both from the enforcement arm of the investigative division of the Commission and those who represent or could be respondents. So our thought would be, we are going to publish before our next meeting the topics that are still open to debate, that we hear about today, that we've seen in writing, that are not stylistic, that are not easily acceptable. And there may be 5 of them, there may be 10 of them, how many ever. And our plan will be for us to decide among ourselves with further public comment at our next meeting what decisions we make about those topics where there is a difference of opinion. And then we will presumably vote to finalize our proposed regulations and continue through the regulatory process. So that would be the plan. Anyone from the Commission want to make a comment, or everybody okay with that plan for today? So with that, I'm going to turn this over to Bridget. And for purpose of comments, we'll take those in the room first, but I want to make sure that everybody who's online has an opportunity to comment on this. I just ask that folks not repeat themselves and tailor your comments to the section we're talking about. And if we don't get to something that you wanted to talk about, we're gonna take that at the end.
Thank you. Good morning, everyone. Thank you for joining us today. For those of you that don't know me, my name is Bridget Guilfoyle. I am the Chief Counsel to the Ethics Commission, and one of my biggest responsibilities since joining the Commission in April of 2022 has been to sort of spearhead the Commission's efforts to update its regulations that had not been updated for decades. The first step in that process was a technical revisions rulemaking package that was promulgated in April of 2024. And that included, as the chair would describe them, non-controversial things that, changing an address, updating certain practices that were already being done, et cetera. They were all simple but very important changes that we were able to accomplish through the streamlined final omitted rulemaking process. The second step in the process is why you're all here today, whether in person or via the video conference. And I do want to thank you all for taking the time not only to be here, but also for those of you that submitted comments or just questions or phone, did a quick phone call to me to ask about something. We really appreciate this, and the process simply would not work if it wasn't for all of you having input into what we're doing. So once the commission had put together what it deemed a substantive regulatory package, on April 22nd of this year, we sent out and sought comments and suggestions on the draft rulemaking by releasing an exposure draft to any interested stakeholders that we had. And I tried to include anybody that I could think of that I had contact information for. Executive Director Fox was very helpful in helping me compile that list. The rulemaking was also posted on the Commission's webpage, and it was also on our LinkedIn page as well. As a result, and as was intended, we received a number of comments, both written and verbal, from various interested parties. A lot of you are here today. Those comments were all provided to the Commission members and were put on today's agenda for them to not only review, but to discuss as we move forward in this process. So the biggest challenge for me was figuring out how in the world do I combine comments in a meaningful way and also allow you to see the section of the act that or the regulations, that we're talking about. So what I came up with, and I'm hoping that it is useful to everyone, I put the comments into two different documents. The Governor's Office of General Counsel provided a significant number of comments. I would do a shout out to Amber Sizemore and her team with the Office of General Counsel. Those comments are going to be in a separate document. The first document is going to contain some of the comments that I received from the other interested parties. And I want to make clear that it does not include every single comment that we received. Some were comments that were unnecessary after an additional comment was made on something else that changed the language. And so some, as the chair indicated, were simply stylistic or those types of things that I did not include because I figured that we might be here until tomorrow if we did it that way. So some of the other comments were just something that we are not able to remedy through the regulatory process. So please don't think that we did not read your comments. Speaking for myself, I can say I read every single comment repeatedly. They were all read, every single one, and they were provided to the commission and they read them as well. So I'm going to pull up and share my screen for the first document, which were the comments that were provided by anyone other than the Office of General Counsel. And give me a second to see if I can actually do this, and I'm probably going to ask Mary to help me.
You want to go to your Teams, go to Teams, share, and select.
She's my technical advisor.
That's scary, all right, and then you'll select whatever.
So we're seeing this now in Harrisburg. Can someone on the Teams just acknowledge that you're able to see the screen with the changes?
Maybe a thumbs up or a raised hand would work.
Ready?
Yeah, there we go.
Thank you, Sandy.
Great.
So this was the actual annex that was provided to interested parties in April. And it is still as was written at that time. So one of the first comments that we received, and I would say probably the most comments that we received on any single topic, was the definition of de minimis economic impact. I'm fairly certain that nearly everyone that did comment commented on this definition. And the comments were primarily geared toward it was inconsistent with the statutory definition and that it was confusing by adding the last sentence, or the last part of the sentence, which is greater than that which accrues to a large class or the general public. I went back through, I have extensive notes through all of my meetings that we were working on regulations, and I spoke with several of the people that were in those meetings, and oddly enough, not a single one of us could find where this definition actually came from. It obviously came from somewhere, or it wouldn't have been in the document. So after discussing it with the Deputy Chief Counsel, we both agreed, and considering the comments, especially the comment that it was inconsistent with the statutory definition with that additional language, my recommendation is going to be that we go back to the original definition, which is an economic consequence which has an insignificant effect, period, and end it there. Anybody have?
Let's see how this individual comment period works. Is there any thoughts, ideas, suggestions about leaving de minimis here like that? I know one of the issues that some folks have raised is, do we publish an FAQ or give examples? And we're going to consider that separately. We have been collecting our cases and also the case law on various sections. That probably is the best way of detailing very fact-specific issues. So there are both commission opinions and case law applying, for example, the de minimis economic impact. It's not that there is a clear-cut, we can give every example out there what would fall within or without. It's going to be a fact case-by-case evaluation. And I think that's the direction that Bridget is proposing, from limiting the definition and trying to make it less confusing. But we'll take any input on that. Anyone in the room? Yes.
Yep, my name is Tom Clem. I'm from the Philadelphia Board of Ethics. I would just note that term, insignificant effect is, I think, hinted at, rather vague and ambiguous, and I think it's referred to by the board, the commission. Leaves a lot of wiggle room, but I think the idea of examples, any type of guidance would be useful. Just because I will submit to you that term, de minimis economic impact, is so often used in the regulations. Any guidance on what that sub-term, insignificant effect, would be very helpful. I think it comes up a lot in the conflict of interest rules. I think it's in the honorarium rules. You will see this term used very often if you run a search term through your regulations. So again, I think any guidance, minimal examples, like guidance, factors, anything would be a really benefit to the regulated community. Thank you.
Appreciate that. Any other comments in the room? Any comments online? Hearing none, let's move on.
The next comment that we received was actually from Mr. Clem's office. It was Jordana Greenwald with the Philadelphia Board of Ethics. It was under the definition of director, and one of the things that we had added was for a business or other organization. And Ms. Greenwald believed that putting that or other organization in that definition is going to confuse people, because we have the word business that is not modified by or added with the or other organization later on in the regulations. And what we were trying to do by adding or other organization was to satisfy the Rendell holding and to make sure that nonprofits were included included in that definition. And so the recommendation that I'm going to make is we're take out or other organization and put in any nonprofit or any nonprofit so organized. And so that way we cover the nonprofit issue, that's a Rendell issue, and we still, that way we're not confusing people later on when we discuss the word business. And we added it in one other place as well, so that we are covered in the, I believe it's in the statement of financial interest section.
And Brendel is a Commonwealth or Supreme Court opinion that held that the Ethics Act applies to or requires listing of directors of nonprofits, is that correct?
That is correct.
Any comments on that section? Any comments online on that section? My only comment is, do we really need so organized? Is it just as clear, including any nonprofit?
I think it's just as clear, we could take it out. The next two comments have to deal with the definition of public employee, which the definition, as we know, is expansive, contains a lot of things. These two comments came from Leanne Davis, the Pittsburgh Ethics Board or Ethics Office, and I think they're both good comments, and I believe that we should add the information that she suggested, which was we currently have the individual, in order to be a public employee, one of the things is the individual is a supervisor of a highest level field office. Ms. Davis recommended that we take out the highest level field office and replace it with responsibility over tangible economic benefits such as hiring, firing, promotion, leaves of absence, and hours of work. I think that's a great comment because that's really what we're looking for when we're trying to figure, that is some of the things that we look at. So I thought that was a great comment and a really great add. And the other one that Ms. Davis suggested was in section E, which was with the authority to make final decisions, she suggested and controls the flow of information relevant to such decisions. And I also like that suggestion as well. If you're making the final decision, but you're relying on the other person to make sure that you're getting the information to make whatever decision it is, then the person that's controlling the flow of that information should also be considered a public employee. I liked both of these suggestions, and I think that we should add them both. I'm not sure if anyone has any additional comments.
And how do those suggestions line up with the statutory definition? Are they consistent, inconsistent, expansive?
I don't believe I believe that they are they are trying to define or to be more descriptive as to, we have contracting and procurement, administration or monitoring grants or subsidies, planning, zoning, inspecting, licensing, regulating, or auditing, or any activity where the official action has an economic impact of greater than a de minimis nature on the interests of any person. So those are very big categories, and I think these two changes will help us figure out who falls into those larger categories, which is what I think this definition in the regulations is intended to do anyway. I think that's why it is so incredibly long and has so many sections, subsections, and subsections. So I really did like both of these comments.
My initial reaction to the control of flow of information may be over-inclusive. I mean, arguably, the clerk who is assigned to walk an envelope down the hallway could be included in that. I understand the point, but it's just something I think we all should consider. I don't think we wanna, our idea of definitions here is to make it clear those who should be included, not necessarily bring into the definition employees, almost like, as Commissioner McKee-Vassallo commented earlier, the bar back that maybe shouldn't have been necessarily included. So I understand the intent and the good intent of that. I just think we should think more about that one particular comment. Any other comments out there?
I have a comment, if I may.
Yes, of course.
I also have concerns. I had not considered the thought with the suggested change to subsection E. I do, however, have concerns about the breadth of the language and who it would encompass with regard to the change of subsection C. Do you mind putting it back?
Oh, sorry.
Maybe it is.
It is still there.
Still there. So it's really the ending clause, leaves of absence and hours of work. And I'm concerned that if we start pulling in anybody that has the ability to approve a leave of absence, such as maybe just a day off, or maybe somebody that does scheduling for a road crew, for example, at a township level or a borough level, that we're going to be pulling in, or at least there's going to be a question of whether we're pulling into the definition of public employee, people who really are quite low-level employees. So before we move forward with these changes, I think we need to do a more in-depth thought about how it's going to impact who is going to be subject to this act, also who needs to be filing statements of financial interest.
That's a great point. Yes,
And just to add on to Director Fox, there's also a section in the regulations that persons who are generally not considered public employees, and among that list are some people who could fall under this new definition, which would, I think, create some confusion. You know, for example, secretaries, roadmasters, other clerical staff.
that's a fair point. So what I would suggest with the commissioner's consent is, Ms. Guilfoyle, consider that comment. I know that there's good intent behind it, and see if, as part of our process, we can incorporate what is appropriate without over-expansive in our next version, and we'll see how that looks and take comment on that.
Okay. Next comment. Trying to find it. Should be somewhere. There aren't nearly as many comments. Okay. This was a comment that came from,
What section are we in? I'm
Yeah.
sorry.
oh, good gracious, I'm so- I missed them.
Oh, that was just the nonprofit. Does I'm assuming no one has further comment on adding nonprofit explicitly, but thank you for raising that. If
So
you do, please speak.
we are in chapter 21. .5 H. Sorry, 25.5.
This is
Aye.
conduct of investigations.
Correct.
Okay.
during our work group meetings, we had decided, or we had talked about adding an advice of rights form to any time that either an investigative subpoena or a hearing subpoena was issued. And it's my understanding that Attorney Lehman had some questions about that.
Do you want to comment? Yes.
Sure. As an administrative agency, I would just question whether that advice of rights form is needed during the investigative process. For example, if we're just talking to, our investigations involve talking to a lot of people for a lot of different reasons. So I do think we need to clarify if we have an investigator who goes to speak with somebody, for example, a secretary, and they say, oh, I can't speak to you without a subpoena. And I can't give you those documents without a subpoena. I think an advice of rights form is a little over the top. I also think it's unnecessary to tell, that secretary, for example, that she has the right to get an attorney before talking to us. Because I'm not sure 100% that she does have her right.
So this was, I think in addition, I was involved in suggesting, just for everybody's thought process, and also maybe for a comment from Ms. Lehman, I come from a background as a federal prosecutor where with grand jury subpoenas, it was routinely included that someone was advised of their rights. And from my perspective, I think everybody has a right to talk to a lawyer, whether you're a secretary or anyone. It doesn't mean you did anything wrong. Oftentimes, you may not be entitled to the appointment of a lawyer, but you certainly can consult with the lawyer. Obviously, the balance here is, does advising someone of their rights burden the investigation for no good purpose? Or does advising people of their rights advance the investigation later because there is no question that they are participating in the investigation knowingly and voluntarily? And, hearing that some people may ask for a subpoena, it may be appropriate, at least in my view, sometimes that for certain confidential records before turning them over, they do give a subpoena. For other records, when we're talking about going to a public entity, those records should be publicly available under the Pennsylvania right to know law, for instance, and should be out there. I don't know that I have a firm final belief on it, but I guess maybe you can comment more on what is the problem. Is there a practical problem if we were to require a notice be just a handwritten form that lays out everybody's basic rights when we were to having the investigative division interact with them?
Can I also ask a question?
Yeah.
I read this differently than the situation that you've just raised. The investigative division will provide an advice of rights form to each witness at the time of service of the subpoena. A witness, in my mind, is separate than the secretary to whom we're asking documents from. I think it's very different to say, we need these documents, and that person say, I need a subpoena for the documents. I don't know that that person needs a advice of rights, but to the extent you're asking for somebody to speak to an investigator, that person does have a right potentially to counsel, or the right to at least seek guidance of counsel. And so I'm wondering if there's a disconnect between what was written and how it's interpreted, and maybe we can write it in a better way, such that it's more narrow to like a subpoena for testimony, right? Because I don't know that a production of documents from a state agency is testimonial in nature.
And that's a very good point, Commissioner. I definitely agree with that. I think my concern is the pretty strict time guidelines that we operate under and our investigators operate under. And I will tell you, our investigators use every day of those timelines. And we've had a problem in the past. I want to speak to a lawyer, okay, lawyer's ready next week, well, I'm out of town that week. And suddenly you're a month down the road and you just want to speak to a fact witness who is in no way a target. So I think that is the concern. I like the idea of putting testimony in there because I think that could streamline and address that concern. The big concern from the investigative division are the strict timelines we operate under.
Understand, and I do like Commissioner McKee-Vassallo's suggestion that subpoena be qualified by testimony. I also don't think this necessarily applies when the investigators are just seeking a voluntary interview. It is the compulsion of the subpoena. Now, obviously, the timeline issue is addressed. The statute requires, and I think the public wants, prompt investigations, and that should be our goal. But having served and sometimes still serve as a defense lawyer, not before this commission anymore, you do have the ability to seek additional time for the commission for good cause shown, and, scheduling issues with witnesses probably fit under that definition of good cause shown at some point.
The defense attorney in me also feels compelled to say that what you believe might be a fact witness very soon could not become a fact witness, and so our determination of a fact witness at the outset should not be outcome determinative as to whether or not that person is a right
Understandable.
attorney in me bristled to that, but I think we can work with this, and I think we all wanna ensure that people have the rights to which they're entitled, but while at the same time serving the general public in a way that's efficient, but also that brings daylight to some of the things that we do find through the investigations that your department really leads a charge on and has found some really problematic things in. It's just how do we balance that, and I think that we would be happy to provide extensions of time to the extent that it is, so that you can speak to key witnesses who have decided to get attorneys.
Thank you.
Any other comments on that issue? I very much appreciate you raising that. Anyone either in the room or online like to comment? Okay, next issue.
Point 22. These comments actually came from Jeffrey Frankenberger, who most of you know, was our deputy executive director. He reviewed the exposure draft and provided some helpful comments, including the fact that there is no consequence stated if the ID does not turn over the information during the time frame. What is the consequence of that? And I agree with him, and I think that there should be some language added to, something along the lines of failure to turn over evidence as provided in this section may result in the evidence being excluded from the record, or something like that. So I would recommend that we add some type of consequence clause into this section. And Mr. Frankenberger also mentioned that there was no corresponding provision for the respondent to turn over information. And I thought about that for a while, and the only time that the respondent is turning over information is generally when a hearing has been scheduled and the notice of hearing has gone out. In the notice of hearing is a deadline for them to turn over information. to the investigative division. So I'm not certain that we can put a deadline that they're to turn over evidence that I'm not sure that they would know that they had or needed until they receive the information from the investigative division.
Makes sense, and for everybody's knowledge, am I correct, Mr. Frankenberger is now also advising municipalities as a solicitor and may be potentially representing respondents someday. So his comments are well appreciated. Is he actually on the line or no?
No.
Certainly with respect to consequences, while it should be discretionary, I think writing in that there could be penalties for the failure to turn over exculpatory information. I think our investigative division knows that it's the commission's desire that these be fair hearings and that both incriminating and exculpatory evidence should be shared with respondent. And I agree with you that as part of the trial process, substantive exhibits need to be shared. Oftentimes, the defense, the respondent may have impeachment evidence that they have a right to not share and use as they deem fit if it's not substantive evidence, but it's to impeach witnesses. So I think your comments make sense, and Mr. Frankenberger's comments should be included. Any other comments on that? Hearing none.
We're now down to 21.24. This actually brought out a lot of comments. It wasn't up there with the de minimis definition, but it was probably, in second place in terms of the comments. The stakeholders that I heard from had a lot of concern over using the terms presiding officer and hearing officer in terms of hearings. And so the idea, of course, we have a definition of a presiding officer. What we don't have is a definition of a hearing officer. So again, something that I discussed with Martin about how do we do a definition of a hearing officer? What are the duties of a hearing officer in relation to the presiding officer? Pretty much everything that we could come up with is already under the job duties of the presiding officer. So I would recommend that I think that we can probably do something along the lines of if it's going to be a presiding officer and if we simply identify the other individual by whatever their title is. So for example, if for some reason I would be doing a hearing, assuming that we go through with that section, I would just be referred to as chief counsel for the commission rather than hearing officer or anything like that. I don't know if anybody else has any comments or feels strongly about leaving in hearing officer in addition to presiding officer. No, don't care. Okay. I'll work out something that we can get rid of and get rid of the confusion between using both terms. And I think we will look at it more closely when we look at the Office of General Counsel's comments.
Any other comments on that?
Sorry.
Just moving to the one definition of presiding officer and eliminating a separate term that was undefined as hearing officer. Okay.
21.228A, which is the treble damages section. Again, this is Attorney Lehman's opinion or comment that she believes that this conflicts with section 1109C of the Ethics Act due to the word shall. We've discussed this issue on a couple of different occasions. And I think what we need to also make sure to note is that, again, this came out when I was discussing this with Martin. Under the language of the statute for 1109, if this is something that is going to be considered mandatory, it's also going to be mandatory for any consent agreement that comes because the commission issues an order, and every order has to contain treble damages if a conflict of interest is found. So I think it's a very dangerous situation that we're dealing with if we are going to construe treble damages as mandatory for every order in a conflict of interest case. And I think we've discussed before that we do have, at least some appellate history that did not construe it as mandatory. We also have the commission back, I think it was 1991, issued a resolution deciding what factors it would use to evaluate whether to impose treble penalties. So I remain of the opinion that this section is necessary, and under the actions of the commission and the way that the commission has acted not only in the past, but what we have been doing, most currently with regard to treble damages.
Am I correct that this proposed section really codifies that 1991 commission policy that was never put through the regulatory process that some would call sub-regulatory guidance?
That is correct. It is essentially codifying what the commission had already issued a long time ago.
And Ms. Lehman, I understand your statutory reading that your view is the legislature has spoken and demanded it mandatory. Any thought of how that impacts your ability to negotiate consent decrees if it was mandatory in all cases?
Well, I think using the viewpoint that was just raised about statutory guidance, I think we can expand this definition to do a carve out for agreements, which would even provide the investigative division with a lot of bargaining power. As in the parties can agree, and should the commission approve, and I'm not trying to say what the wording will be, that's not my area of expertise.
Sure, no, but we appreciate your viewpoint.
To the effect of the parties can agree and the commission may approve, not imposing treble penalties.
But if we did that, wouldn't that suggest that the legislature did not mean that it was mandatory in all circumstances? Because otherwise we would not have the authority to have a regulation with a carve-out.
But aren't we doing that? I guess I'm just, it's just very hard to put the two together. That we're creating some sort of carve out from what the legislature said, and then saying that we can't do any kind of future clarification or carve out during this process. So I just think that section should be open to further discussion.
Understand, appreciate that viewpoint. Anyone else with a viewpoint on this? Okay. Next.
We're getting very close.
You're teasing us because we still have the Office of General Counsel's comments and anyone else's comments.
Sure. Yeah, Yes, we do have quite a few comments yet, but in terms of this particular version, I believe that we are finished with the comments from anyone other than the Office of General Counsel. And
So why don't we go to the Office of General Counsel's comments, because that may also incorporate other people's thoughts, and then we'll open the floor. Again, as we said before, some of your comments we've already incorporated. We're only stopping on those issues that are of note that we're still considering.
I'm hoping that Mary taught me well. Sure. See, okay. Okay. And as indicated, we have Amber Sizemore's here from the Office of General Counsel, and I believe that we have Sandy Stoner as well, and I think Addie Abelson was also on the call. All of those individuals are with the Office of General Counsel and are experienced in doing regulatory work. So, I'm not sure why okay. This is going to be difficult just because for size reasons. Mary's gonna help me. Bless you, a couple more times. Oh my God. Yeah, that's a toughie. Let's move it up a little bit and see if we can. The comments are pretty clear.
You just focus on the comments and just tell us what section it's on.
Okay, this is in the definitional section, which is 11.1. We refer to immediate family in at least, on more than one occasion in the regs, but we don't have a definition for it in the regulations. We have one in the statute. The recommendation is that we include that definition in the regs, and I fully concur with that recommendation.
Certainly makes sense. I don't see that as controversial. Does anyone have any comment on that? Hearing none.
Okay, the next section is still in the definitional section where it comes to clear and convincing proof. The Office of General Counsel comment was that should this be clear and convincing evidence rather than clear and convincing proof? I tend to disagree respectfully with that comment. I think that as I put in my notes, that evidence is used to show or demonstrate facts, and whereas proof is the result brought about by that evidence. And so I think that clear and convincing proof is what we are saying. That is our burden in this case, not clear and convincing evidence.
Interesting linguistic tool. You have preponderance of the evidence is one standard. You have proof beyond a reasonable doubt. I don't know.
So we are taking out the,
We'll have to consult with our legal scholars and settle that definition.
sure that I have. Okay. And I do agree that with the changing of the language from hesitance to hesitancy. So the next one, again, we are back in the definition section under the infamous de minimis economic impact. The comment was, would it be helpful to provide more direction or to be able to describe through an example what an economic consequence that has an insignificant effect is. Alternatively, this I believe is the first time that we spoke or are mentioning that FAQs might be helpful to provide some examples. Or maybe we didn't mention this earlier, but the de minimis we've changed. Obviously, the definition has been taken back to what it was to begin with, so I'm not certain. My concern about trying to include examples of anything in the regs, I think, is not what the regulations are intended to do. I don't think that we need to, or that we should be putting examples of something in a definition. I do think that an FAQs for the website would be something that would probably be worthwhile, and something that I would ask that you, as a commission, consider.
So just to comment, we already do have FAQs, although they're extremely high level. We don't get down into these individual definitions. I think you had pointed out that we did publish a list of appellate decisions. I checked it. I don't see that we have anything specific on the meaning of de minimis economic impact. It also becomes difficult with teaching. We're talking about this exclusion to the definition of conflict of interest, and the question always comes up, what's a de minimis economic impact? And it's difficult even for us to always answer that question. I wanted to mention that only because I think it might be difficult to also give examples in an FAQ that people can reasonably rely on.
We may want to, I know we have published some newsletters and educational items on cases. We may want to go back and just find some cases where we've either said it's not de minimis or it is. I take the comment from Philadelphia's board of, it would be great to have X dollars is de minimis, X dollars is not. I think it's probably our collective view that that's legislating, and that is not our goal here, although it would provide a bright line. But we may want to think about more, and certainly the comment about trying to educate more about what falls in that exception is well taken. I don't know that we can do that in the definition and have it as a regulation, but we'll think further about that. Any other comments? Clearly, this is an issue. I do know that we, at least in my tenure on the commission, have had a couple cases where we've thought about and made mention in our decision about whether something was de minimis, but it was a very fact-intensive, somewhat discretionary call.
And I believe there's appellate case law on that. I don't know why we don't have that individually listed.
Maybe we can look at that, either, in conjunction with the regulatory process or, separately as part of the education that we're doing. Because clear from the comments that there's a lot of interest in getting more guidance.
I agree.
Okay, we're moving, still in the definition section, to presiding officer, which we've already discussed. The next one would be the private pecuniary benefit. And I actually really like this suggestion as well. This was, does the word receipt contemplate the use of something by someone? And the recommendation is to add the receipt or use of something, because someone would be able to receive something but might not use it, or use it without the actual receipt of it. And I thought that was a great example and something that I had not even thought of, and I would recommend that we change that language to what OGC has recommended.
I think that's a great idea, and I think we've had cases where people in townships have used but not received township equipment that we have determined to be private pecuniary benefits. So, yes.
Sticking with the private pecuniary benefit, the gender neutrality throughout the document. There are occasions that we will be able to make it gender neutral by basically repeating, if the public official then the public official, instead of saying then he, or something like that. And there are a number of them throughout that OGC recommended that we do, and I think that we should.
And I'm strongly supportive of that. Disappointed that we didn't, to tell you the truth.
Because I think the reason that we haven't is because, statutorily, unfortunately, he means
Right.
everyone.
I go back to Senator Alan Kukovich, who, he was a House member then, I guess, who required gender neutral language when we were drafting legislation,
And I
a
think
long
it's.
time ago. But I'm very supportive of it.
Okay. Okay. I'm just going to answer this one, not necessarily because I think it needs changed. The question was police chiefs and executives, and I think we added that because we get a significant number of, questions, either phone calls or even an advice request about people who are not the chief of police, but who are very high up in the police department. And so when we were doing this, we decided to add police chiefs and executives. If you would prefer, I could add police in front of executives as well, if that would make it clear or more clear to anyone, but I
I
think
think the
that,
lack of the comma means police defines chiefs and executives.
Is that the term that you use to, isn't it ranking officers or something like that?
I would say something about either ranking or sworn officers, which is another term that's often used for police. But just to make clear that we're talking about, or are we trying to make clear that we're talking about sworn officers for lieutenants, captains, et cetera, in that, is that what executives is supposed to entail?
I know, and Mary, why don't you comment? I mean, I know we generally, police officers, sworn officers are not included under the
Correct.
Ethics Act.
Correct, and I think the idea we're trying to get at here is we're talking about the highest ranking person within a police department. And everybody between them and the patrol officers depends upon what their duties are, as listed in their job description or elsewhere. So if we can incorporate the idea of the highest ranking person within the department.
And I think we do that with police chief and executive.
okay. Moving on to, again, this is a question that I'm gonna have Mary weigh in on. She doesn't know that yet, but I'm going to. This is under the, again, we're still in the definition section under public official. That the ability to enter into contracts would make an advisory board or a person on an advisory board a public official. And the question was, would this include advisory commissions entering into memorandums of understanding with other state agencies that would probably not include the payment of money? And My initial thought, I don't have a lot of experience with MOUs, but I will say that I think it's what the intent of the parties would be as to whether the MOU is considered a binding contract. It's my understanding that generally they are not considered a binding contract. So I don't believe that they would generally be considered, within this portion of a public official, or the advisory commission and public official under that exception.
So, and Amber Sizemore's here from OGC, and these are their comments, but my understanding of MOUs, there's a bucket of agreements, interagency agreements, MOUs, intergovernmental agreements, some of which are considered contracts for purposes of approvals, and some are not. I don't know that the intent of this is when we have one agency entering into an agreement with another agency to essentially transfer money between them. My comments to that comment were need more info. So I don't know that I can be that helpful.
And isn't it also, this particular section is looking at whether or not the public body is expending public funds. So contract in that particular section is modified by the provision that contracts go to evidence of whether the public body has the power to expend funds. There are other provisions, I think as we give opinions, it is a case-by-case basis on advisory commissions of how much power and influence do they have, whether they're purely advisory or whether they're actually making public policy and or expending money as to whether their members come under the jurisdiction of the Ethics Act.
Sure, and I wonder how many purely advisory committees do enter into binding contracts when they're in an advisory, whether they even have the authority to do that. I think I would like to speak with OGC about this issue further.
Yes.
And get a little bit more clarity about the background for the comment.
Very good.
Moving on to. Okay. The definition of sworn complaint. The recommendation was to delete the word sworn, since the word sworn is not used to modify complaint at any other portion or part of the regulations. And since we have the definition as including signed under penalty of perjury, I think the word sworn could be deleted if that is something that you would want done.
It would just be the definition of complaint. A
Correct.
complaint is a declaration of complaint signed under penalty of perjury.
Yes.
Sense?
Okay. This section the comment was that they wanted to add public employees because it was not there. In section 11.2, construction. I'm not sure how you feel about this, but this is actually pulled verbatim from the stated purpose of the Ethics Act. I'm not sure why public employees were not included in that, the stated purpose that was in the Ethics Act. I don't think it's going beyond the purpose of clarifying, interpreting, or implementing a statute if we would include public employees in this section. So I would recommend doing it.
Good.
Okay, now we're into the advice opinion area. 13.1. E. I think this is just more of a semantic type of thing. As to the language of as docketed by the commission in that section. It says that we may elect to have the opinion or advice issued as docketed by the commission. The concern was, of course, that it's the legal division that, or chief counsel, that actually dockets this information, not the commission. So I think it's more of a, as docketed by the commission, which would include us, or if you want to change it to as docketed by the legal division, whatever your preference is. I have no trouble leaving it the way that it is, but I see the point of, since it is docketed solely by the legal office, then we should put something in there like that. If you go down to in that same section, to subsection I, the last word in there is, who is the subject of the advisory. And OGC points out that this is the first and only time that we use the word advisory, which is interesting to me because I just assumed that it was in here a lot more. And I like their suggestion of changing it to, instead of advisory, to confidential advice or opinion consistent with the rest of the section.
Agree.
Okay. Right. Opinions. And this, I'm sorry, losing my place here. This is under 13.3. E, related to opinions being a defense to criminal or civil penalties. And the recommendation was, we have this same type of provision for advices of counsel. This is for the opinions issued by the commission. Should we not have the same language for both? And I think we should.
I just want to point out that the language that's in the regulation tracks statutory language. There's a lot of statutory consistency between that language. I think they mean the same thing.
Right.
I think it's odd that they're different, but I think it was just pulled in verbatim from the statute.
Understood, but I think if we're
Explain
in the
it.
process
Yeah.
of rewriting the regs to be consistent, we're not adding anything. I think the consistency in the regs is probably better to achieve.
On to section 13.5. It does appear that we are missing a section here. It says subject to section 13.1H and I. If you look at I'm not sure why subsection G was not included, even though it deals with the same information. So I think that, yes, we should do that. We should add G into that section.
Okay.
All right, moving on to chapter 15. This was a question about, should we not also include public officials and public employees? This section, 15.2C, only pertains to public officials. 15.2D refers to public employees, so I do not believe that we should have public official or public employee in that particular section.
I agree. I think it's statutorily inconsistent.
Okay.
Okay. In 15.2H, there's a suggestion that we add a definition for third-party professional services provider. I'm not sure what that definition would be, to be perfectly honest. If anyone here has any suggestions, I'm open to what a definition for a third-party service, professional services provider would be.
I believe that, if I'm recalling correctly from our discussions, the reason we added this was because there were local government laws that had recently been changed to allow third parties to serve as township managers and in other roles. And the idea behind this addition was to incorporate that same idea and that filing requirement into our regulations.
Do you see any way that we could get a definition, or would you leave it as is?
I think we could probably come up with a
Yes.
definition as this is a service provider hired by, a local or state entity to perform the services, to perform certain governmental services.
I can pull some language from those local government statutes and see if I can redraft this provision to
I think it's a good
incorporate that.
idea to define it,
Mhm.
since we're using it for the first time. I think we did want to incorporate the trend to privatize certain high-level government official roles that may not be conducted by someone on the payroll of the local government. It may be through a third party.
Yes, I think we need to be careful with that. I think there's a risk, we don't wanna make it too broad.
Correct.
Right, because we don't want anybody that's performing any service for a governmental entity to get pulled into this definition, so.
Well, right now, if you're looking at subsection H, it only is someone who is designated solicitor or engineer.
Mhm.
So it would only cover people in those two roles. And the only thing I think we're concerned with is what if they're not with a law firm or an engineering firm?
Isn't that what the comment is? The language in the comment here suggests that we should add comma or provider, which would make it more expansive. Because for example, what if a person's providing auditing services for the township? We would want that type of professional service. But we wouldn't want like a municipal third-party garbage collecting service to have to require. So I think that's the tension that's being called out here, right?
Yeah.
Yeah, I think the entire clause needs a second look, to be honest, and I'm happy to propose some language that I think will be consistent with those other governmental law changes and still incorporate this idea. So if I may, I'll pull that and provide some proposed language.
Please do so.
Sure.
And certainly we welcome the regulated community's comments on a revision of that section. Let's make sure we call that out before our meeting, since that may have substantive impact on folks.
Okay, we're moving into chapter 17. And 17.4. Again, the issue is whether there are examples of what is described in 17.4A. I think it's the same comment or the same discussion that we had before, that that we're not really supposed to be identifying examples in the regulations, but we might be able to find some cases that we could put in an in an FAQ document as something to look at for certain examples. That's probably, I think, the best that we can do with that question.
My sense is this was written to protect lawyers to not disclose all of their clients, which under law may be confidential and privileged.
Same question, again, asking for decisions or examples or case law of what received in connection with public office or employment means in terms of expense reimbursement. We have our e-library, which contains all of our advices and opinions. This is, again, such a fact-specific circumstance that I don't believe that we would be able to further define what that is in this particular instance. But again, open to putting up some case law in an FAQ.
Okay.
All right, moving on. Now we're in chapter 19. And this is one that I know very little about, which is the section that, in terms of forms and filing, 19.1, that this current system does not allow, the current system does not account for the fact that state employees are permitted to use OA's system for filing. And Mary, I'm gonna.
Sure, we have approved a few larger governmental entities to use an online system that they created for filing, still asking for identical information that our SEC 1 form asks for, the one that we publish. I would still consider the outcome of those, the form that results from filling it out through their online system, the SEC 1. So I have a language proposal to incorporate this. What I would propose is we phrase it this way: a person required to file a statement of financial interest shall file Form SEC 1 as prescribed by, published, and revised by the Commission. Or put an or instead of the and. But incorporating the idea of prescribed by, which means we've given the approval for them to do it in that way, and we basically blessed it. We'll accept them through that whatever that format is.
Is it really prescribed, or is it just as approved, published it, or revised?
Approved would be all right. I would then, in the future, want to bring those to you guys for approval, any requests like that.
Okay. To section 21, where we're going to hear Linus probably more than you ever wanted to hear. This is the investigation, the chapter on investigations as well as hearings. And as you know, we're trying to get away from using the commission as the default for every action that is done in the regulations. And in doing so, what we tried to do was we did definitions for executive director, for the legal division, administrative division, and investigative division. So when we are going through, I think the first one that we're going to get to is 21.5. And this is a comment that on that section, which talks about the commission may employ or be assigned staff, including attorneys, investigators, etc., as may be required to properly investigate, review, and dispose of complaints or investigations. Their concern is that shouldn't this be the executive director, not the commission? I'm not certain that that's accurate, since the commission is the person, we are employees of the commission, including myself, including everybody that works for the commission is an employee of the commission. So I don't know that we've ever had this section come up before. I'm assuming that it was put in the regulations at the time to allow the commission to hire individuals that would be investigating the complaints and whatever they needed, or the commission needed, to get the complaints investigated and properly disposed of. The only true people, and again, the only two people that you hire are me and Mary, specifically. All others are hired by the executive director, but we're all employed by the commission. So I'm not totally sold that this particular section needs to be modified. Do you have a comment, Mary?
I agree with you. I think it's fine as is.
Although the only thing that I would comment on is D appears to be focused on the investigation and complaints. One, we probably, given what we described before, want to delete hearing officers from there. And if you think about, if it's focused on the investigation of the complaints, it really is the executive director who we have delegated hiring authority for staff, attorneys, investigators. So if it helps eliminate even an appearance of a Linus issue, I don't see a problem having that as the executive director may employ with the deletion of the words hearing officers.
I think that's fine too.
I agree. Moving on to, same type of comment. We talked about, in this case, investigative staffs as described in section, the next section that's down, which is 21.5E. And I'm based upon this comment, the suggestion is that we designate exactly who we're speaking about. The members of the investigative division. I don't think that we need to, we already have a definition for investigative division. And that specifies what its duties and responsibilities are. I don't think that we should be outlining job titles of the people in the investigative division for a number of reasons. Since we are clearly not commingling, adjudicative and investigative in this section, I think we've satisfied the Linus concerns by separation. Plus, I have some concerns about naming specific titles when those titles can change. We've seen that happen as recently as when Mr. Frankenberger left. So I think that we're safe the way that it is written in that particular section.
I think that's right, and we do want to, as we've said before, give the executive director the authority to decide how to structure the office. The only comment I'll make is, shouldn't we have consistency between D and E? So for instance, we have staff counsel before we have staff including attorneys and investigators. We talk about special investigators. I just think I would ask to look at it again and just be consistent with how we're describing everybody. If it's special investigators, let's use that term the whole time. If it's just investigators and attorneys, but I think the goal of the commission is to give the executive director the authority to decide how she best wants to organize the office at that particular time, given the resources we have.
The next comment is down in the same section in subsection H. This is speaking to the ability to do subpoenas. The ability to do depositions. And the concern being is that these regulations have a specific provision that speaks to superseding the General Rules of Administrative Practice and Procedure, as it relates to subpoenas and depositions. However, there's no discussion of depositions here, nor any procedures for taking them. And it doesn't appear that it appears anywhere else in the regulations either. I think this section is more along the line of the sworn statement, that not necessarily a deposition. I think there are two different things. But again, I do think at some point we need to either eliminate the section that speaks to superseding GRAP on depositions, so that would permit the investigative division or another party to do a deposition. I think one of the cases that we had recently where the witness had some very significant physical limitations. And I think it would have, maybe if we'd had this ability to do depositions, then maybe, we could have done it that way. So this particular section, I think is fine, with the sworn statements. Mary, do you have any?
Only that I would love to have the ability to do depositions as a tool.
What was the history of superseding the general administrative procedures?
To be honest, I have no idea. I think there are some things that it appears that they wanted to be able to do that were in direct contradiction to the general rules of administrative practice and procedure. And so they simply superseded those, not consistently, but in a number of sections as we go along. At the bottom, it'll say that the, GRAP is superseded on, and I'm not sure of the reason why, other than the fact that they wanted to do something that was opposite to something that was in GRAP.
Well, this section is for the investigation stage,
Statement.
so it's
Yes.
not a deposition, and I think your comment is right that this is a sworn statement process. I think there should be a consideration of whether or not we want the general administrative procedure on depositions as part of the hearing process or not.
And I think we have it marked later in the hearing process about doing depositions. I'm gonna move on to, these are all comments. Sorry?
You have a hand up.
Oh, Sandy, I don't want to answer that.
If I could, hi, Sandy Stone here from OGC. If I could just clarify what I was talking about. GRAP applies unless by regulation an agency or commission supersedes it and they have the ability to do that. My point was you've superseded the GRAP provisions related to depositions in that section. But you do not address depositions anywhere in your regs. So now you have no ability to do anything in your regs different from GRAP, but you've also superseded GRAP. So I think somebody could argue that GRAP doesn't apply, right? Because you've superseded it, but you haven't commented. And I think they could argue you can't take depositions then under GRAP. So I was just pointing that out. You can do whatever you want. I just think if you're not going to supersede the deposition section of GRAP, you should just eliminate that one word about superseding the depositions so that you can have that flexibility to do depositions if you determine to.
That's a fair point, Sandy. Thank you very much. And I think the consideration that I would ask everybody to think about is there collateral consequences to opening up depositions? This is not, full-born litigation. Is it going to be cumbersome if GRAP applies and there may be depositions from either side as part of the process? But that's a very good point that I think I would ask Mary, you to think about further and us to identify where we come out on this before the next hearing so we can discuss that further.
Will do.
I also see something on the chat. I don't know if it's worth clicking the chat box if we missed a comment from someone. Oh, okay.
Okay.
Yes. Why don't we take a 5-minute recess? Okay, let's go back on. Do we need to do anything on the video or? Okay, thank you. Bridget, do you remember where you left off?
I hope so.
Okay.
I believe that we are in section, sure, 21.5, conduct of investigations.
Yep.
We just went through the deposition issue or the sworn statement issue. I think we are now down to page 3. The authority to question a witness.
I thought that's where we left off.
Again, I think this is one of those ones where they want to, the suggestion was to specifically delineate who those staff members are, and I think that we're safe with just leaving it as investigative division.
Other than, let me just open to OGC. Do you have concerns that we should be delineating particular people? I mean,
Sandy, do you wanna, since this is your comment?
This is Sandy. Is Amber answering? I don't want to speak over
No,
her.
I was saying this was your comment, so maybe you're best positioned.
So I'm not saying that you need to delineate all of those people. It's just as I read through all of those sections, it was a little confusing. It referenced subsection E several times where it says as delineated or as authorized in subsection E. If you don't want to delineate them, I would just remove the reference to subsection E. If you believe that the definition of investigative division is sufficient in and of itself, I'm fine with that. I just want to make sure there's consistency, because there in F you say investigative staff members identified in subsection E, but you generally give a grouping as opposed to identifying them. Again, in G, you say as designated in section E. I'm fine with you not listing them all. If you have an investigative division that you know who is in and who isn't, that's fine. I would just say then they're not designated there, and I would take that out.
That
That
makes a lot of sense. Yeah, that makes a lot of sense, and we probably created more confusion with that cross-reference. I think our desire is to give the executive director the flexibility to organize the division, but have that division with the authority to do the items that are enumerated in this regulation.
Right, and that makes perfect sense. I think if you then take those references back to a particular section, remove those references, then I think it's clearer.
Thank you, that's a great suggestion.
Okay, so that was
But-
each 1, 2, 3. Was there a comment?
No, I think that covers, I know we then have an issue about the, I don't know if I'm jumping too far ahead, but there was some questions about extensions.
Yes. Let me get to, so when we get to that, we're now down in subsection K. The comment was that this section was a little confusing. Should you say upfront when and by whom the findings report will be issued, then address the extension request issue, who can ask, who can grant it, etc. From someone who doesn't really get involved in that section a whole heck of a lot, I don't necessarily believe that we should be, the findings report should be first. Especially since a lot of times we get extensions or other things going on in cases that will never lead to a findings report. So I think in terms of, order, I think that they should stay the way they are unless Mary has any comments.
take out some, the IV, which is 4.
The findings report will be issued with this.
Yes, because I think 3 below needs that.
I agree with you. Does anybody else agree?
And it's very clear in the statute, I mean, it's not something that has to be expanded upon.
I agree.
Makes sense.
And I think that there is some cleanup that can be done in this subsection K, where we're talking about the commission. I think it should clearly be investigative division or executive director instead of the commission. I do agree with OGC's comments about it getting a little murky from a Linus perspective.
And I agree that this was an oversight on my part, especially K, respondent shall file a response to the findings report of the commission. I've actually already changed this on my in-house copy that I have. And there's a couple other ones that were oversight that other people have pointed out as well that were changed to make sure that it was the investigative division and not the commission.
What about the issue of the extension for good cause shown from a Linus perspective? It does seem to me that we can, courts oftentimes will be asked to rule on ex parte submissions. Do we need to, though, because as you rightfully said when you were talking about Linus before, it is also an appearance issue. Do we want to say that a request for an extension shall not disclose any underlying facts of the investigation and should only describe the procedural aspects that require an extension of time?
Whatever, I agree, and I think Mary and I have talked about this before, that it is a little troubling that we're in this spot, but I know that Mary has indicated that they have been trying to, to scale back on the information that is provided to the commission, and I think to what you were actually speaking of, that the investigative, whatever investigative limitation is occurring, whether it's, witnesses can't be, aren't cooperative, or there's, a gazillion, phone records to review, and with that, I think we can keep in there, and I do think that we should include, again, like you said, something in there that indicates that they will not describe any substantive facts of the investigation.
So I think we should write something in there and leave that out. And again, even the characterization, we had that discussion before. It is good cause that a witness scheduling of a witness is delayed because the witness has counsel. I don't know that we need to have characterization that witnesses have been uncooperative. That would suggest a potential appearance issue. We're not making any decisions other than a gatekeeping. Are you moving along promptly? Is there good cause for a continuance? And I think we're able to decide that without blurring the lines, just with those basic facts. So if we can add some language here that takes into the Linus concerns, but I don't know how else. I don't think it makes sense to designate a commissioner who then has to recuse her himself.
I'm fine with that language. I think it's consistent with our practice anyways.
Good, okay. Go ahead, Bridget.
Sure. We are down to the granting or denial of an extension request requiring a majority vote. I think, again, we're handling this by doing what you just said. And if we take out what is now subsection 4, findings report will be issued within 180 days because it's basically a repeat of what's in the next section 3, so I think we're good with that. And again, I think changing the commission in subsection, what is now gonna be subsection L, same, that it should be the investigative division. And unless an application is made for an extension, that will still be to the commission, so I think we're good there. Alright. This is another, that was an oversight on my part, subsection L2, new matter raised by the respondent. In respondent's answer does not require a reply by the commission. Like I said, already changed that to investigative division. And again, this goes into what Sandy from OGC had said about superseding GRAP relating to subpoenas and depositions. I think we've resolved that issue as well. So confidentiality, which is 21.6, what a person can or cannot disclose, or can disclose. There's some line S concerns when we speak of a hearing or petition for reconsideration, which is before the commission, whether that can be disclosed or not, or whether it should be something that's before the commission. I think it's a matter of grammar, where we speak to relating to a complaint, preliminary inquiry, investigation, hearing, or petition for reconsideration, which is before the commission. I think we can resolve this matter by doing complaint, preliminary inquiry, or investigation, or a hearing or petition for reconsideration, which is before the
Do that, or what if you just deleted which is before the commission and added relating to a pending? And then have the long list of everything ending with petition for reconsideration.
I disagree.
Yeah.
Pending, these confidentiality provisions survive even after a commission order has been issued. I think adding pending is, could,
Okay, then
yeah, I would.
add the or, so do complaint, preliminary inquiry, investigation, or hearing or petition for reconsideration before the commission.
Yes, that'll work.
We're down to number 5, A5, where it says communicating with the commission or its staff. In the course of a preliminary inquiry, investigation, and hearing or petition for reconsideration by the commission. I think again that this section is primarily dealing with, when you talk about, again, preliminary inquiry, investigation, those are investigative tasks, and then the hearing or petition for reconsideration would be commission tasks. So, I mean, I think that we can work this, that we get rid of, go ahead, Mary.
I think it needs to be everyone within the commission.
Okay.
We need to have the ability to not have the confidentiality restrictions apply to any discussions, including Bridget's staff and the investigative division staff.
So should we leave it communicating with the commission or its staff? I think the concern is that people are going to mistake commission staff for a Linus issue. That we're speaking to the commission staff, not investigative staff or administrative staff. I'm not sure that I agree with it, but that is the concern. I think it can be left, but we'll defer to you.
Isn't this communicating with the commission? Lay it out. The investigative division, the administrative division, or the legal division.
Okay.
In the course, because there are gonna be certain times you're asking for an extension, you're gonna be communicating with others, and this is where what ordinarily would be confidential is not confidential, you're not breaching violation. So I think if we delineate each division, we solve that problem.
Okay, moving down to hearings in 21.21. As you know, the chief counsel has the ability to grant an extension of time for an individual to file a response to a findings report. The chief counsel has can grant the first one, any additional, or the second one has to go to the chair. OGC's concern is that it's inconsistent with 2120L or I, I'm not sure which that is. Maybe, I'm not sure what 2120 is. We go from 21.6 to 2121, so am I, Andy?
I thought they were referencing the investigative extensions here.
Right.
Yeah, it was
If I could comment, and it may be just my inability to differentiate between your sections, and you say request for extension without saying for what in any of these things, but it seems to me that they appear to be mixed in some cases. If you're saying here in the hearings, it's only a request for an extension to respond to the report, that's one thing. In the section before 2020, again, there were many references to requests for extensions. And again, to me, it was confusing. I couldn't tell what requests for extensions were permitted. Was I requesting an extension for, the time to complete the investigation? Who's requesting extensions? If I were the person trying to understand how to conduct myself before your commission, I just would like a little more clarity about what I'm allowed to do and what I'm not allowed to do, and what the extension request is for, and to whom it goes for what particular thing. And I guess, you're used to your practice, and so this section relates perhaps only to the response to a findings report, but there may be some other thing that you're asking. This is an answer to that, I suppose, but what if I need something else? So to me, I was just getting confused, and it may be me, not you. I'm just saying, as I read through it, I thought it was unclear who to go to in what circumstance for what purpose.
We'll take a look at that, and it actually looks like 21.5L creates the confusion, because that does mention findings report and extension by the commission. And maybe we just need to delete the commission there, but I think it's a good point, Sandy, and we'll go, and maybe we wanna be careful, and every request for extension, say request for extension of what?
For what, okay.
It's a fair point.
And I think that speaks to the next question or the next comment as well. Same comment, and the next one as well, further requests. So I think moving moving down from 21A, we're doing 21B. And I think this is a good, again, the discussion of whether it should be presiding officer versus hearing officer. And now we have, chief counsel being designated. So I think that, we've at least eliminated the possibility that if we're getting rid of the hearing officer designation and going with presiding officer and then using the individual's specific title, I think that eliminates that. I think that we are good on that issue once we work it up without the hearing officer being in those particular sections. This comment is about for the ID in terms of, we are now in 2122. 2122A1, which it speaks to the investigative division turning over any exculpatory evidence within 10 days of receipt of an answer being filed or as soon as the ID identifies it, whichever happens first. The comment was that, well, one, was this our intent? If the exculpatory evidence at the time the answer is being filed, 20 days before it turns over evidence that it intends to use at a hearing. And also there does not appear to be an extension, anything in here that allows for an extension of time to turn over exculpatory evidence. That basically was the intent of this provision. I don't know that, I'm not sure that we should add another extension into but again, I think Mary would have more comment on that than I would.
So I was just asked by our executive director, do we need an extension for turning over exculpatory information? And I hate to give a lawyer answer, but it depends. Because sometimes exculpatory information, are we talking, as a former prosecutor, I also include exculpatory information as information that may mitigate, not just exculpate. And if we're looking at it like that, there could be a decent amount of, for example, phone records that could be argued a certain way, or at some kind of voluminous, I had a recent case where calendar entries could have been viewed as exculpatory. And that takes some time to disclose. We do our disclosure electronically. So I do, and I was part of the discussion with this, and I agreed with it at the time, and now I'm not so sure I agree with myself. I would, I think we should have something in there for an extension, but now it becomes confusing as to who am I getting that extension from without violating anything else.
Well, this would be the presiding officer at the time, although, I guess we tied this to the answer. So we're at the stage of the proceeding, the investigation is done, findings reports issued, answer has been filed, and it's tied to identification. So you have to turn over what you've identified as exculpatory within 10 days, not waiting to the eve of trial, or when you identify it.
Right.
So, we did intend not have an extension to it. If we need it, we should be thinking about it.
Not sure why you would need, once it's been identified as exculpatory of a duty, I'm not sure why you would need an extension. If it's an extension to package it, right? I think isn't that mitigated by saying you will be sending it?
Sure.
right? I don't, I'm just struggling with why you would need an extension, but I also don't, I'm not in your shoes every day, so maybe maybe you can provide some more color to why you might need an extension.
I think that our discovery process isn't purely, first of all, it's all done electronically, so we have to download it from our case file system, put it in a different thing, get it numbered, get it on a disk, and then send it out. And again, sometimes that can take more than 10 days. It just does not, it's not that easy to work with these documents that can easily number in the hundreds of pages.
Maybe the best thing to do, just looking at the structure of this section, is take that for good cause shown, the presiding officer may extend the deadline, and put that at the end. So it may extend the deadlines. And that gives flexibility. We're in a hearing. It's the presiding officer, which means by definition, we're in the hearing, you're gonna have to make that request and copy respondent's counsel. And if they're objecting to it at the time, the presiding officer is making an adversarial determination.
Okay.
That gives, I think, everybody fairness and flexibility. But at the same time, has earlier deadlines for exculpatory information, which I think we all agree the respondent should have as soon as possible.
Yes, I agree.
That makes sense. All right. See, there was a comment about authorizing depositions, which I think we will take under advisement. We did have that situation where we were considering a deposition where a witness was going to be unavailable.
Right. Yeah, I think that, again, we either provide for depositions in this section or get rid of the superseding draft. The next section was a question on the transcript. That this implies that the Commonwealth or the Commission has to pay for the transcript before it gets it. Is that what is intended? Well, we do pay for our copies of transcripts. I think the question is, it makes it sound as though the presiding officer might be withholding. To be honest, we pay for our transcripts. So the reason that was put in there was since we recently, in several cases, have run into respondents that were very unhappy or unaware that they had to pay for a transcript if they wanted a copy. And so I think that's why that particular phrase, when we talked about it, was entered, was put in this way.
Should it say copies of which may be
do.
obtained by respondent
Okay.
on a payment of appropriate fees? We're paying for a transcript no matter what.
Right.
That will just clarify what we intend.
Now we're into the conduct of the hearing, section 2125. Again, going back to this is actually one where it sounds as though that the legal division would not be able to give advice to the commission or to the presiding officer. Obviously, that's not what the intent of this section was.
No, I think the comment is if the legal division, and we
Right.
haven't decided this, I think, finally, but if we are going to delegate the presiding officer to the legal division, who then gives advice to the presiding officer at that point in time? That was, as I read that comment.
But if we're delegating it to the hearing officer, or to
We don't have a hearing officer.
I know. If you're delegating the presiding, if you're delegating to the legal division the ability to preside at a hearing, there would be no need for a legal advisor to the legal advisor.
Right, they just suggested clearer language.
Yes, and I agree. I think it could be clear, and I like the way that they had set it out.
That makes sense.
Okay.
But I think we still need to put to a debate among the commission for next, whether we want to authorize the delegation of the presiding officer to the legal division. So if we can just put a pin in that for our next hearing.
Sure. The next section that we're in is the motion section, 21.26A. Where the comment is that why would we let someone bypass the presiding officer when filing a motion?
I think that's a good point. I mean, don't we designate the presiding officer as soon as we know there's going to be a hearing?
If a hearing has been requested and dates have been provided, generally, yes, we would have a presiding officer at that point.
So I think that's right. We don't need the chair or vice chair.
Yeah, I was trying to figure out what motion would ever be filed before we would be getting to that point, and I couldn't come up with any.
I think we should
So-
leave it as presiding officer, because at the very least, the chair or vice chair will designate a presiding officer.
Agreed. Okay, that's where we're getting close. We're now into the commissions, chapter 23. Again, dealing with the presiding officer issue, that we are now referring to a presiding officer as the individual who is presiding over a meeting and rather than a hearing. So I think that we can do this simply by adding to the definition of presiding officer that individual who presides over the conduct of hearings and or
Meetings or hearings, yeah, I think meetings is the primary job, and then add hearings.
agreed. So I think that can easily be fixed.
Although what we should do is for a hearing, the default is not that it's going to be the chair or the vice chair. I think the chair or vice chair may designate. Because if you look at the default 23.3B, it's only if the chair or vice chair are absent that there is the designation of someone else to be designated.
Yes,
I think we need to have a section that allows the designation for every hearing of a presiding officer.
for every hearing. Aren't we in the meeting section?
Well, it's general provisions,
Okay.
and it's defining presiding officer.
Okay, I just wanna make sure that I'm with you.
I think this just gives the authority. I think you just need to add a section for hearings.
And again, the concern was that the presiding officer language was getting confusing. Again, if we change the, the suggestion as you did, I think that takes care of most of the concern.
Bridget,
Yeah.
if I may, what What about presiding commissioner? I don't think, I mean, I know it's a little cumbersome, but just to throw it out there as an alternate, that may address some of these concerns.
That's simpler, I mean,
It's up to you guys. I mean, it's up,
that makes sense to me. We don't have to add or names or titles. I think that's a good suggestion, if we can go through that.
so now, after we get through all of the members to preside at meeting questions or comments, the next one, if I recall, is the code of conduct for the commissioners. That was really a gender neutrality comment is the first one in 23.23A. And this one, I don't know that 23.23A3.3. If a commissioner recuses from a matter, the commissioner will receive copies of minutes of the meeting containing deletions as to the recused matter so as to not disclose the matter to the commissioner.
We say redactions. So it's clear that we're getting everything else rather than deletions.
Okay, so I can change that.
I think that was the intent of the comment, that we still get everything else.
Yes. Okay, and we're now going down to wrongful use of the act section. I'm not gonna lie, I don't like a lot about this entire chapter. I don't like the way that it's handled. I don't like the procedure. I don't like much of it at all. Gotta be honest.
But this is in the statute.
A lot of it is in the statute, yes.
Isn't the big picture solution, I think the general counsel's office did raise a Line S issue with
Yes.
the commission making preliminary
Absolutely.
determinations. Isn't this where it does make sense that we should designate a commissioner to make a preliminary determination,
Yes.
and that commissioner then recuses him or herself from
Idea.
the further deliberations?
And I would like to say that was my brilliant idea, but
It was your idea.
But it was my brilliant idea based upon what we did at the Department of State.
Well, it was.
So it wasn't something that I came up with, but
Right.
but that is how it was handled with the different boards and commissions under the Department of State umbrella. So I think it works.
So there's separation,
Yes.
but then there's also not tape. Anyone from OGC, I know we have that in several sections, but any comment about adopting a procedure where the chair designates a commissioner to do the preliminary review and then that person is recused?
This is Sandy Stoner. I think that makes great sense. Yes.
We will write that in and ask you, Sandy, or someone from OGC and any other interested parties, just to double check how we have written that in. But thank you for raising it. We do agree that we shouldn't be serving both roles.
Mr. Chairman, my only concern with that, and I think it's probably a good idea when we have a full board, but if a member of the commission happens to recuse himself because of some conflict, and then the commissioner that made the evaluation has to, then we're down right now, we won't have a quorum to yet actually vote on the matter.
That's a fair point.
Did you take that from me yesterday? We talked about that yesterday, or Monday, or whatever, on
Oh,
the
did
phone,
we?
yes.
Oh, I don't remember that, but, I mean, that's the only problem with,
Right.
our limited board that we have right now.
So that is an appeal to the
Absolutely.
Senate, both Senate caucuses to please replenish our 7-member commission. I think it's a fair point, Dave, but I think from a legal perspective,
I agree.
it is the solution.
I agree.
And normally operating at 7, we should be fine. And this is a rarely used, we
Yeah.
probably have had less than half a dozen in my tenure of wrongful use allegations. None of them, I think, have gone beyond the preliminary inquiry stage.
Not in my tenure here.
Rob, you,
Many years ago, one went to a full investigation, but I can only recall one instance in 40 years.
you're comfortable with this approach?
Yeah, oh, absolutely.
Okay.
The only other comment that I would have is moving into appeal of determination under 25.4, where we speak to the commission issuing either a rule or an order to show cause, and whether that is a prosecutorial function or not. It actually, although it's generally a prosecutorial function, it is not exclusively a prosecutorial function. As in my prior days as an administrative judge, I would issue rules to show cause to why something should not happen, why something should not occur, whether a motion should be granted or not. I looked up other agencies that do similar to what we did at the Department of Insurance and otherwise, and I think Mr. Chair, you and I both talked about issuing an order to show cause in another instance. So I don't believe that is a flaw or a fatal flaw, but I think we need to, like I said, redo this section, redo this procedure, and then go from there.
Agree. Does that bring us to the end of the OGC comments?
Oh, I hope so. Sorry.
I think it did. And these are very helpful.
They were very helpful.
They
Let's
were
not let our,
Yeah.
extraordinarily helpful.
while you're double checking, let me just ask, anyone in the audience have any additional comments that they'd like to raise with the commission? Yes,
Yeah, real quickly, can I approach the podium?
please.
Yep. I'll be brief, I know it's late in the day, and I'll give my usual pleasantries. Again, my name is Tom Clem, I'm with the Philadelphia Board of Ethics. I'm here on behalf of our board. Again, I want to thank everybody for this process, very transparent, this has been very useful for us. By way of quick background, for those of you who are not familiar with the Board of Ethics, we cover the ethics rules here in the city of Philadelphia. We have concurrent authority with our law department to give general advice regarding the State Ethics Act. We do not have the ability to give binding advice protections regarding the State Ethics Act, but I will submit to you, we are the front lines. When somebody has a state ethics questions, they're the first ones to come to us. I won't belabor the point because it's mentioned in detail in the letter that my superior, Jordana Greenwald, the general counsel, submitted to this commission. But we really encourage, as part of this amendment process to the regulations, further clarification on the word government body, the term government body. I will submit to you, and I've heard Martin mention a couple times, Martin Harder, 80% of my communications, whether I'm asking on behalf of the general counsel staff or a requester who's authorized to talk to the State Ethics Commission, regards this definition. It is fundamental in the world of your post-employment rules, who is your former governmental body. I will submit to you the Philadelphia administrative tier is very large, very detailed, for lack of a better word, very incestuous. A lot of control, a lot of overlapping. So who's somebody's former governmental body is not an easy answer. Any attempts to help spell that out, give us definitions, clarifications on how that works would be extremely helpful. I know it's been talked about a couple times, how who counts as a public employee, can be often harsh, create harsh results. I will submit to you application of that 1 year post-employment rule in my 10 years experience has been one of the harshest. That can really hit people hard. So to us, it would be very helpful to know to the extent where it applies, who is your former governmental body. The second place we see this come up very often is, for better or worse, the city of Philadelphia has many what I will call pseudo-governmental entities. These are entities that are related to the city. They range in all types of formalities, organization, very common in our tourism industries, where a government entity is formed and it collaborates with private enterprise. So what will happen is these pseudo entities, a high-ranking member, and they usually are high-ranking members, will be a member. And the key question for us under the state conflict of interest rule is whether, for example, a city council member can take a decision, vote on a matter affecting that pseudo entity. Now, if it is a nonprofit, and this goes back to the Rendell decision, it will. You cannot do that as a conflict of interest. But the State Ethics Act does not apply if that entity is a governmental body. So this is critical. So for our purposes, for the conflict of interest rules, whether they can take official action affecting those pseudo-governmental entities. And I will submit to you again, they range in all shapes, sizes, organizations, power, maybe not an easy answer. But again, I'm here today, again, serendipitously, no exaggeration, probably 80% of our questions to you regards this question. So again, it's on our wish list. I know you guys got a lot of other stuff going on. Not quite Christmas in July, but I thought I would throw it in there just again for your consideration.
Much appreciated.
Yeah, thank you.
Thank you very much. Anyone else who's present here? Anyone else online? So I want to thank everybody. The written comments, our former colleagues who have submitted comments, our current staff, everybody who has participated. It has been incredibly useful. We are going to take these comments into consideration, including, I think, some good questions that I don't know the answer to from the city of Philadelphia. We will intend to, with our agenda and our announcement of our, is it September meeting?
Yes, September.
Which will be in Gettysburg, which
Yes.
hopefully also we will be able to have some online access to, be able to comment or get comments as we move forward in our regulation process. Special thanks to Bridget, who told us we would never do regulations, and I think the light is at the end of the tunnel, and I think it will be better for having gone through this process.
Well, if I could just thank everyone who participated today. Again, as the person responsible for this, getting some of these questions that we received from everyone was something that I never thought would be as helpful as it was in going through and really defining some of the issues that we have in these regulations that say, Mary and I, who, we've been here a little over 3 years, having the people who have done regulatory work give us some of these comments was just invaluable to me. And I think it'll be invaluable in our process moving forward.
And if I may also.
Yes.
Do we have, will people be able to continue to give feedback as the door is not closed for feedback?
Correct. Yes, we welcome any additional comments as we're moving the process along. And then obviously, as part of the state regulatory process, there will be formal comments periods, but we actually encourage this beforehand because we do intend to incorporate all of these good suggestions as part of our published proposed regulations. So, I think that was the last item on the public agenda, am I correct?
Yes.
I'll entertain a motion to adjourn.
So moved.
Second.
All in favor? We are adjourned.